with the CRPD committee organized by DARE and NUI Galway. My name is Hanshu Liu, and I'm one of the DARE PhD researcher based in Maastricht University in the Netherlands. Please call me Han. I will chair the webinar today to introduce you each panelist and moderate the QA. It is my great pleasure to be here to learn from our four distinguished speakers as well as the audience. So before we start, I'll first hand over to the scientific coordinator of the DARE project, Professor Eleanor Flynn from the Center for Disability Law and Policy at NUI Galway to say a few words about the DARE project. Eleanor, can you please take the floor? Thanks.
Thank you, Han, and welcome everybody. It's great to see so many familiar people registered and attending today. So I just want to talk a little bit about the DARE project and its purpose before we get into our speakers for this morning. So DARE stands for Disability Advocacy and Research Europe. And what we are doing with this project is we're working with 14 early stage researchers based out of 7 partner organizations all around Europe. So our partners come from Ireland, from Portugal, from Switzerland, from Iceland, from the UK, and from the Netherlands, and of course from Belgium. So in this project, we are working as academics and non-academics together to train an interdisciplinary group of researchers who we hope will be the next generation of disability rights researchers, not just for Europe, but for the world. And the idea of the Marie Curie program is that every researcher travels to a different country to take up their position, and they take the skills and knowledge that they gain from the project back to their own countries after they finish their research. And what's really important in this project is that our researchers have the opportunity to apply their research skills, not just in an academic environment, but also by going on secondment with non-governmental organizations where they can apply the skills that they have gained through their interdisciplinary research projects in practice in a way that's going to be useful and meaningful for disabled people and their representative organizations. And all of our researchers in this project are working on issues that are related to the UN Convention on the Rights of Persons with Disabilities in different ways. So some projects are looking at the experiences of particular groups, for example, women with disabilities or disabled children. Some projects are looking at specific issues, for example, issues affecting older people with disabilities or issues affecting people who are marginalized in different ways and maybe experiencing violence, for example. And so all of our researchers are working on really interesting ideas and applying them to different contexts, but in light of the UN Convention on the Rights of Persons with Disabilities, which is why we've organized today's webinar, because we think it's really important that not only researchers learn how to apply their research and make it useful to implement the UN Convention, but that researchers and other advocates learn how to engage with the UN Committee on the Rights of Persons with Disabilities to bring research and ideas before the committee that can be useful for the committee in its work. And this is particularly important as many of the countries that we all come from are being reviewed by the UN Committee on the Rights of Persons with Disabilities about the progress that they've achieved in implementing disability rights around the world. So I'm sure we will learn a lot today from all of our speakers who have different experience of working with and on the UN Committee on the Rights of Persons with Disabilities. And I really look forward to the discussions we're going to have this morning. So I'll hand back to Han to introduce our speakers.
Thank you, Eleanor. So just briefly introduce the topic we'll cover today. The focus of our panelists in this morning's public session will be under top tips for researchers, lawyers, and civil society organizations in engaging with the Committee on the Rights of Persons with Disabilities of the United Nations, or the CRPD committee. Overall, we want the panelists to reflect on how research and advocacy, which are the core themes of DARE, as Eleanor just mentioned, can be used in each of these processes. So we have 4 panelists joining the webinar today. They are first Professor Jonas Ruskus from Vytautas Magnus University in Lithuania, who is also Vice Chair of the CRPD Committee. Professor Teresa Degner, former chair of the CRPD committee, Dr. Janos Fiala Butora, lecturer in international disability law at NUI Galway, and he's also a human rights lawyer. Last but not least, Ms. Dragana Sirik Milovanovic, director of the Europe Regional Office London from the organization Disability Rights International. So in the next hour, each panelist will present for 15 minutes in the following order: Teresa, Jonas, Dragana, and Janos. Following the presentations, there will be an open Q&A with the audience until noon. So before I introduce our speaker, I just want to mention 2 or 3 housekeeping matters. The first is that we will use Zoom Q&A function. So I hope to ask all the audience to send your questions or comments through the Q&A function. You can find it, I think, at the bottom of the window. Next to the chat box, there's a Q&A function. But if you can't use that function, please raise your virtual hand and you can ask the question during the Q&A at the end. And also, we also encourage the audience to tag @ResearchDare to join the discussion on Twitter. And lastly, we also provide a closed caption, so you can also turn it on in the Zoom function. I think it's in the, if you click more, you can find open subtitle there. And without further ado, let me introduce our first presenter, Teresa, who will focus specifically on the following means of engaging with the committee, including submissions to consultations, general comments, days of general discussion, and inquiry procedure. Teresa, can you please take the floor? Thanks.
Thank you very much, Anne, and I'm thankful to be allowed to be the first speaker in this interesting webinar. I have been on the committee for 8 years. That's the time you can be. That's 2 mandates, and so that was from 2011 until 2018. Well, I forgot to set my timer. Now I set my timer. I want to talk about 3 points in my 15 minutes. I want to first introduce the instruments the CRPD committee has to monitor their convention. Then I want to secondly speak about 2 instruments, the consultations of civil society, academia, and others in general comment and days of general discussions. And thirdly, I want to talk about a 3rd instrument called the inquiries procedure, where also DPOs or NGOs and academia and universities play a big role, can play a big role. And I will finish my presentation with showing you a publication which was done for the 10th anniversary of the CRPD committee in 2018. And this publication, I hope that the organizers of this webinar can put on their website so that everyone can download it. It is free, freely available, and it was done during my time as member and chair of the CRPD committee. So that's what I want to do. So let me start with the introduction. The CRPD treaty has, like other human rights treaties, a number of instruments in order to monitor international human rights conventions, and in this case, the Convention on the Rights of Persons with Disabilities. And there are 6 instruments. The first one is, of course, state party reports, which have to be submitted to the committee and reviewed by the committee. And I think that is the topic my colleague Jonas Riskus will talk about. The second instrument is individual communications. These are individual complaints which can be brought forward also to the committee in Geneva, and they will be reviewed, and then there will be a decision on the individual communication. It's like a court procedure where individual court cases are brought. The third the procedure is in the inquiry procedure, which I will talk about later. That is also a complaint procedure to the committee, and it is about grave and systemic violations of the rights enshrined in the convention. The fourth procedure is the adoption of general comments, and these general comments are documents issued by the treaty body, the CRPD committee, and it is usually about legal interpretations of provisions of the treaty, and I will come to that later. The fifth instrument is regional consultations and days of general discussions, which are on specific issues or themes which are in relation to the treaty. And the day of general discussion I will talk about, because it is usually part of the procedure on how to make a general comment. And the sixth instrument is general statements, that is more on actual topics like the pandemic or some disaster or conflict. And these are also documents issued by the treaty body. So I will now talk about two of these mentioned six instruments. I will talk about general comments and the day of general discussions, which is part of that procedure of making a general comment. And then I will talk about a third instrument, and that's the inquiry procedure. The general comments and days of general discussions is now my second point. They are, of course, regulated in the CRPD as well as in the various regulations of the work of the committee. And the most important of these is the rules of procedures and working methods. And these can be found also on the website of the treaty bodies. And it is always important to look at these rules of procedures in order to understand how can you get involved with the committee, who can get involved, and what is the procedure in making this instrument or, let's say, document. As I said, the general comment is, oops, I have to rush up because I'm already way ahead. Anyway, general comment, as I said, the general interpretation. So far, the committee has adopted 7 general comments on various issues. For instance, general comment number 1 is on Article 12, equal recognition before the law. And the last one, general comment number 7, is on meaningful participation of organizations of people with disabilities in implementation and monitoring of the CRPD. And there are several steps in making a general comment. Usually there is a decision of the committee to have a general comment. Then within the committee, there will be a working group appointed where not all members of the committee, which are 18, but let's say 4 or 5, become part of this working group, and they draft the first version of that document. Then that draft is sent out to the public, usually on the website of the treaty body. And then there is usually also a day of general discussion taking place, either in Geneva, can also be at other places. We had one general discussion taking place in New York alongside the State Party Conference. And then in that general day of discussions, many people are consulted by the committee. The committee listens to civil society organization, the committee listens to academics, the committee listens to state parties, the committee listens to other UN agencies like WHO or World Bank or UNICEF, and the committee listens to other agencies, whoever is accredited with the committee, and that accreditation happens before the day of general discussion. So it's always worth a try to get accredited for that day of general discussion, and then you will see if you have time to talk at that day of general discussion. And then at that day of general discussions, very, very valuable information is gathered, and that will be analyzed by the committee, and the committee will go back to its draft and then make the final general comment. And I think what is also important is that the consultation is the people who consult and take part in the day of general discussion deliver a written submission to the committee, because those are very important documents. The CRPD committee usually makes a synopsis of all the statements. And just to give you an idea how many submissions we received on General Comment number 3 on disabled women, for instance, we received 55 submissions. On General Comment number 5, on Article 19, independent living, we received 105 written submissions. And all those documents are analyzed by the committee again, and then most of it goes into the final document. And the general comments are guidelines for state parties on how to implement that specific article. Let's say Article 6 on disabled women, or Article Article 19 on independent living. And if you look at the website of the committee, you can also find most of these submissions, because the committee puts all these submissions on the website as a kind of collective memory of what has been put into this guiding document. The general comments are not binding on the states, but they are very authoritative statements, and many courts have already cited these general comments when they applied a certain article of the convention to a particular case. I think it can be said as an example of the importance of engagement of civil society that, for instance, with the general comment number 3 on women, I think if it were not for organizations representing indigenous women, or representative organization of LGBTIQ+ community, I think the general comment number 3 on women would not have been as strong on these points, because these views were entirely brought in by civil society, and it was very important for the whole committee to have these voices, and they could not be pushed aside as for instance, submissions by individual academics where you said, yeah, that's one voice. It's maybe someone who has a big reputation, but the committee listens a lot to DPOs. And if there is a strong representation of these voices, that it counts a lot. I come now to my third point, the inquiry procedure. It is also regulated in the optional protocol of the CRPD and in the rules of procedures. And it is a confidential procedure regarding reliable information indicating grave or systematic violation by a state party. And the procedure is as follows. First, information is compiled, and I need to say that anyone can start an inquiry procedure. It is not that you have to be a victim. You don't have to have be affected by that violation yourself, but anyone who has reliable information on grave and systemic violation of the CRPD in a given country, which needs to be, of course, a member of the treaty and the optional protocol, can bring this information to the committee. Then the committee decides whether or not to establish a procedure. Then it appoints 2 or 3 committee members to look into the information, but also go into the country and talk to stakeholders. And then a decision is taken within the committee whether or not the committee found evidence of grave and systemic violation of rights enshrined in the CRPD. And then those findings go into a report. That report is given to the state party, and then Sometimes it's made public in the report of the committee, but it depends a lot on how the dialogue went. And most of the time, the latest time of publication, because it is a confidential procedure, the latest time of publication would be in the state party reporting of the country, because that's when, even if the report has not been published, that at that point the state party will be publicly asked about what have you done about our findings from that inquiry procedure. So during my time at the committee, we had three procedures: one against the UK, and one against Spain, and one against Hungary. And in the UK, and in all those three procedures, the committee found evidence of grave and systemic violation of human rights violations of, and in the UK it was about austerity measures, social cutbacks the government took, and it had a detrimental effect on disabled people. In Spain it was about inclusive education, and the committee found that there was evidence that there is a systematic discrimination against disabled people in the school system, and that particularly in people with intellectual disabilities are left behind. And in Hungary, it was about institutionalization and not fulfilling the obligation under Article 19 and other articles in deinstitutionalize the disability policy in Hungary. So what is important to, I have 27 seconds left, so I think I stop here. So I would like to, in the discussion, go into the questions of what is important when engaging with a CTT committee, what can you do right or wrong. But at this point, I would like to show you a publication, and if the organizers could show the publication now, then I could tell a little bit about the publication on 10 years work of the committee. I don't see it on the screen yet, but it is a brochure the committee did for its 10 years anniversary in 2018. And yeah, this is it. Thank you. It's called Towards Inclusive Equality, 10 Years Committee on the Rights of Persons with Disabilities. And you find not only wonderful pictures of all the committee members of the first 10 years in there, but also you find information about all the instruments I just mentioned, information about what kind of concluding observations, what kind of inquiry procedures, what happened, what kind of individual complaints, and it is free of charge available on the Research Institute website of Bodies, which is my research institute, but it is a German-speaking website, which is why I think it is hard to find. And maybe the organizers of this event can put this on their website. And thank you so much for your attention.
Thank you very much, Teresa. So for our next panelist, Jonas will talk about how the committee takes on board shadow reports and other information from civil society during the dialogues with states in committee sessions. So Jonas, can you take the floor, please? Thank you.
Yes, thank you. Thank you. Hello, everybody. Good afternoon. It is a pleasure to participate today for me at the webinar, and also it is a pleasure to meet here my dear colleague and former chair of the CRPD committee, Professor Teresa Degener. Let me share with you about how the committee takes on board the shadow reports and alternative reports and other information from civil society, including and especially from organizations of persons with disabilities. At the beginning, I would like to start by introducing my work at the committee and to some general lines of the work of the committee, and then to put them into relation with alternative reports. I'm at the committee from 2014, and from 2018 as I'm a vice chair of the committee. And like my fellows of the committee, holding many responsibilities and duties. So I would like to share my experience and my work as a member of the committee. As you probably know, the main role of the committee is to assess the progress that state parties of the convention have made in giving effect to the obligations under the convention, and then to provide the specific recommendations to the state party, what we call concluding observations. As you probably know well, the assessment by the committee is made on the basis of report, official and alternative, verbal and written reports provided to the committee. Members of the committee analyze these reports, both official and alternatives, and through dialogues with the delegations of the state parties and through consultations with the organizations of persons with disabilities, members of the committee seek to verify and to specify the information for having evidence, for having information, and for being able to substantiate the recommendations to the state parties. Such are general lines of the work of the committee, and we may look inside a little bit to that process and the expected outcomes. Also to look to other activities in which the reports by organizations of persons with disabilities and other civil society are of crucial importance. There are several, I would say, bridges or junctions between the committee and the state party, including and especially the civil society and organizations of persons with disabilities, bridges or junctions that ensure the provision of information, including from civil society, on the implementation of the convention in the state party. One of the most important bridge between the committee and the state party, including the civil society, is a country rapporteurship or country rapporteur, a member of the committee appointed by the bureau, by its bureau, for summing up all information and drafting the concluding observations to the state party, including for preparing other members of the committee for constructive dialogue with the official delegation of the state party. I was a country rapporteur for probably almost 10 countries. Usually the country rapporteur works on the reports of the countries from his or her region. Thus, originating from eastern part of Europe, I was a country rapporteur for Moldova, Armenia, Latvia, Ukraine, Poland, Slovenia. Recently, a few months ago, we held online session, and there were one state party, one report of the state party considered at the session, and was Estonia. I was a country rapporteur for Estonia, but not necessarily from the region of which comes the country rapporteur, but I also was a country rapporteur for Spain and a Southwestern Europe country, and actually working on the report of France and appointed as rapporteur for Japan. There are some specific and privileged links between me as country rapporteur with these countries, since I was living on several years in France with persons with intellectual disabilities, and having good relations, including visits there with the experts and the organizations of persons with disabilities of Japan. Thus, the role of the country rapporteur at same and some level of his knowledge, or at least awareness on the regional peculiarities, is very important. My experience is that the interaction of the country rapporteur with the civil society organizations is critical. I would advise the representatives of organizations of persons with disabilities to get in touch with the country rapporteur and to discuss with him or her about the main issues in the state party of the convention that they observe, and then how to discuss on how to address the committee, what is the best way to inform the committee, the members of the committee, and also to discuss on how to write the report that will be informative as much as possible. Probably the best example in my experience of country rapporteur was the work on the report of Spain. CERMI, the umbrella association of organizations of persons with disabilities in Spain, has addressed to me. They came to Geneva and we spent a few hours to discuss on the main issues that persons with disabilities face in Spain. Even more, organized by a relevant global association, I met as well with the representatives of organizations of persons with psychosocial disabilities of Spain, and was extensively informed about structural discriminatory provisions that are upheld by the state with regard to persons with psychosocial disabilities. Additionally, the concerns expressed directly to me as country rapporteur have been reiterated in a written alternative report by organizations and by umbrella organizations. So I was well informed for analyzing the official report, for raising good questions to the official delegation. And the outcome of all that was the concluding observations to Spain, and that have been well tailored concerning issues in relation to the rights of persons with psychosocial disabilities. Similar experience I'm getting actually now with regard to France. Even before the quarantine, I was contacted by representatives of organizations of persons with psychosocial disabilities, again, of France, and I could hear from them the first-hand experiences arising from structural discriminatory provisions in the state party that could never have that information that I could never have without meeting them in person. Certainly, it will be reflected in the concluding observations for France, as well as the very specific issues regarding autistic persons in France, with whom I am in contact now, and who provide me with and already have provided the committee, the secretariat of the committee, with the report on the specific structural discriminations regarding autistic persons. And their reports help me a lot to include questions regarding autistic persons to the official, the official structures, to the government of France in the list of questions, or we call it list of issues, that are made by the committee to the state party before the consideration of the state party's report. Within all of this, I wanted to highlight how important for civil society preparing the alternative reports to contact and to meet the country rapporteur who leads the preparation of recommendations to the state party. It doesn't mean indeed that I underestimate the importance of interaction of civil society with the whole committee, as well as provision of the reports to the committee, including its secretariat, which strongly supports the work of the committee. Alongside the contacts with the country rapporteur, the contacts and meetings and interactions of representatives of organizations of persons with disabilities with other members of the committee, and the provision of the written reports are none less important, or I would say it is of crucial importance. I can provide also with I would say negative examples, not negative examples, but probably some missings when alternative information to the committee was missed from civil society. I can take a very recent example from Estonia, a country rapporteur. I was a country rapporteur, as I told, and the whole committee was very well extensively provided with alternative information regarding almost all articles of the convention, about the implementation of the convention in the state party, but some areas were missed. And I mean, first, the issue that about the issue of, again, persons with psychosocial disabilities are facing there. So me as a country rapporteur and my colleagues have interpreted the official reports, both written and verbal, and respectively provided recommendations. But it is true that we missed the first-hand experiences to make our recommendation more specific and more tailored to the state party. So what is expected by all members of the committee, country rapporteur, but all members of the committee, that all alternative reports are extensively covers all articles of the convention from 1 to 33 and provide information on every article, on implementation of every provision in the state party. At the same time, we need to have more specific information, include when I say more specific information, I mean, first of all, if I may say, intersectional information about intersection of disability and for example, of women and girls with disabilities. That is of crucial importance. It was a very good report also made by CERMI, by umbrella organization of Spain, I mentioned before, and there were very detailed, very tailored information regarding women and girls with disabilities in Spain, and that is really important to have such a look which provide deep information in depth, and with the experiences, first-hand experiences, also indicating the discriminatory provisions in the state parties. So intersectional information, I mean about intersection of disability and other characteristics. I mean the disability and women and girls with disabilities also. So it comes to the issues, such issues as right to integrity of a person. I mean the issues of forced sterilization, forced abortions, also support provided to women and girls with disabilities and their empowerment in all areas of life. Or same, for example, when it comes to intersectional information. So I mean children with disabilities, and that is a very important issue today. And I will come a few seconds after then on this, but especially when it comes children with disabilities, when it comes institutionalization, when it comes violence against children with disabilities, about and especially alternative care and right to family environment. Also, when children with disabilities always appear on the issue of education, on inclusive education. Same intersectional information, it is which is also might give some specific look to the state party. Also, that my colleague mentioned before about LGBTI plus and disability. So in some countries or many countries, it might be missed, and so I think that is also important to show that disability has multiple grounds, and then is interconnected with multiple grounds, and I would be back to Estonia. So they mentioned this issue, and necessarily we provided the concerns and the recommendations to the state party about. So we were able, the committee, to inform and to provide it with relevant recommendations to the state party that about that persons, LGBTI plus persons with disabilities might face including violence and hatred against them. Also, for concluding, I want to say that it is not only the reports or the state party reports we're working on, that my colleague mentioned before. So there are working groups that are very important because they are all prepared or kind of jurisprudence of the committee or providing guidelines or providing other information to the state parties. For example, I'm co-chairing and chairing the working group. One is with the Committee on the Rights of the Child, and we are preparing. Actually, trying to finish now the statement on the rights of the children, and including an alternative with regard to alternative care, because probably there is general discussion on alternative care in September, organized by the CRC committee, and we wish that the issue of children with disabilities, including in alternative care, should be and must be addressed. And for concluding that, one more information, about regional consultations we are actually holding. Probably you heard about that, and very soon there will be regional consultation with Western European countries, and I moderated the consultation with Eastern Europe and Central Asia. It is really interesting experience. Several hours. Organizations of persons with disabilities shared with the members of the committee their experience, their perspectives, and on the basis of that, on the basis of regional consultations, we will prepare guidelines for deinstitutionalization, including in the context of humanitarian crisis and pandemic. So I see my time is out now. So for conclusion, I want to emphasize that the participation of organizations of persons, the providing of alternative reports, meetings with members of the committee, providing oral and written information, and it is always very useful when it is made together and hand in hand with academics. So that is of crucial importance for the members of the committee to prepare the well-founded and very relevant and well-tailored, country-tailored concluding observations to the state party. Thank you very much.
Thank you very much, Jonas, for the presentation of the useful information. So now let's move to the third panelist, Dragana. She will share her experience on how to build a coalition and write a good shadow report, also organize impactful side events. Dragana, please take the floor. Thank you.
Thank you very much. Good morning, everyone. It's a great honor to be part of this panel, and I thank you for the invitation. I'm Regional Director of Disability Rights International, a human rights organization based in Washington, D.C. DRI documents human rights abuses, publishes reports on human rights enforcement, and promotes international oversight of the rights of persons with disabilities. We also train and support advocates seeking legal and service system reform, and assist governments in developing laws and policies to promote community integration and human rights enforcement for persons with disabilities. We have worked in over 25 countries and issued numerous reports. My experience predominantly comes from my work in Serbia while I was working as a country representative. I'm also founder of a local organization called Mental Disability Rights Initiative of Serbia, which is a DRI affiliate. And as part of our work was, of course, communication and different actions that we took toward with CRPD committee, but also other UN treaty bodies. So my experience comes from writing alternative reports, participation in different sessions during the consideration of country reports or thematic meetings. I participated in preparing written submissions on different occasions for general comments, or now mentioned DI regional consultations, for example. And also I took part in organizing impactful side events during the CRPD committee sessions. What I would like to stress about the preparation of contributions in general is that you need to get familiar with the process. What is the purpose that you're contributing to? What are all the available mechanisms? And what kind of contribution would have the biggest impact? This is important because the form matters and will depend on a particular process, the language you're going to use. Sometimes Alternative reports, for example, allow you to be comprehensive, address all the articles of the convention, but also sometimes you have very short space, a limited amount of words that you're able to submit. So it's always important to balance between the impact you want to achieve and what is the format of the consultations and communications with the committee. Of course, what's really important before you even get involved in preparing an alternative report or any kind of contribution is to get familiar with the practice of the committee, go through the concluding observations or general comments, guidelines, whatever is important for the contribution and for the process you want to contribute to. If it's alternative report, it's always important to go through the government report and address all the key issues that the government failed to address or stated facts that were not correct. If in sessions, it's really important because sessions are very time limited. It's important to coordinate with other participants, together with side events. Collaboration will allow you to cover more topics or to converge together to advance one particular issue that you find very important to be discussed at that particular point. So while you have to really be aware of the format, you also sometimes need to be vigilant, creative and flexible depending on the advocacy opportunities that may arise at certain period of time, which are not for example, being planned in advance, such as the situation with the COVID pandemic and the consultations that took place last year. And I will mention a bit later an initiative that we had as a civil society during last year and its impact on the current process of the regional consultations. So what's really important before you start writing and preparing alternative report is to gather evidence and identify the issues of a particular concern. What is that you really want to communicate to the committee? Do you want to do national or cross-country research and reflection? And also don't underestimate personal stories and powerful testimonies, which should be part of your contribution. So it doesn't simply has to be legal analysis. It really needs to be substantiated. It needs to be grounded in the experiences of persons with disabilities and how the situation in this particular country affects their lives. When it comes to networking, it can happen at different levels. For example, you have umbrella organizations of persons with disabilities, but also in Serbia, for example, we have a national platform of human rights organizations which was established to monitor implementation of recommendations of all UN treaty bodies. This is important mechanism because in this way we can follow practice of different treaty bodies, not only the Committee on the Rights of Persons with Disabilities. We can mainstream disability issues in other alternative reports and also ensure participation of persons with disabilities in preparation on alternative reports on the Convention on the Rights of the Child, or CEDAW Convention, or Convention Against Torture. So it's really, really important to have a good collaboration with other human rights organizations within the country you work in, which will allow you to mainstream disability issues in the reporting process. Regional networks are very valuable because they allow us to learn from each other's experiences. We've been part of different regional projects along with the Center for Disability Law and Policy at Galway University. We prepared side events which took place during the country consideration of Serbia report. That allows us the collaboration. For example, we collaborated with Human Rights Watch and Validity Foundation and others to hold a joint side events so we can maximize the impact of a specific issue that needs to be highlighted at a certain point in time. I want to tell you a little bit more about the latest initiative. Last year, after the pandemic started, we joined 6 other organizations in a global disability monitor platform. It was called COVID-19 Disability Rights Monitor. And we launched a study, a survey that was which had the aim to collect all the testimonies of persons with disabilities during the pandemic. So the importance of such collaboration is that the major disability rights organizations got together and sent a clear message about the issues that are urgently need to be addressed. And this was taken into account by the Committee on the Rights of Persons with Disabilities. As a result of this initiative, among else, the committee has formed a working group, and the process of regional consultations is now ongoing. As a group of NGOs, we will still be working to contribute to this process, both in terms of submitting different contributions in a particular country, on particular countries, but also the overall process and the process of later on commenting on the guidelines that will be prepared by the committee. So there are a lot of ways to communicate except of official written submissions. It's important to follow different processes, different discussions that are going on. Whether you want to make contribution on a particular country, situation in a particular country, or you want to raise awareness about issues that are predominant in a particular region. For example, we did a lot of advocacy on the Western Balkans region together with organizations from Bosnia, Kosovo, Albania, Turkey. So you can really identify different opportunities and different modalities to contribute with your research and with your evidence. Because while CRPD committee members are amazing experts and they're doing incredibly important work of holding countries accountable, they wouldn't be able to do that without contributions, without the evidence provided by persons with disabilities and other civil society organizations who are taking part in these processes. So don't hesitate to get engaged. We have always found useful to communicate with the Secretariat, especially when it comes to preparing side events, who will, of course, provide you with all the logistic information and what you need to be aware of when considering a side event during a CRPD committee session, and do collaborate with other organizations. Communication is very important. It's very important to let each other know what you're working on, what the focus of your work currently is, so you can maximize the opportunity. For example, if you want to pay a specific focus on deinstitutionalization, like we did with the COVID Disability Rights Monitor, or if you want to address issues affecting a particular region or a country, such as inquiries that were previously presented by this distinguished committee members. So I will be available for your questions if you're interested in any particular details, but I will now allow other participants to get involved. Thank you very much.
Thank you very much, Dragana, for introducing us the experience from disability organizations and human rights organizations in engaging with UN human rights mechanisms. Our last panelist, Janos, will take on the topic of how to build a successful case to bring before the CRPD committee using the individual complaints procedure under the optional protocol. So Janos, the floor is yours. Thanks.
Thank you, Han. I'm very happy to be here today with you. As Han mentioned in the introductions, I'm a lecturer currently, but I'm also a practicing human rights lawyer. So I have seen how the process of appearing before the committee looks from the perspective of lawyers and how it looks from the perspective of researchers. So this is what I would like to talk to you about today. Individual communications are one specific way of reaching the committee or appearing before the committee. And it essentially means taking a case, taking an individual case before the CRPD committee. We are all aware of the CRPD, but the CRPD has an optional protocol, which is discussed less. And countries who have ratified that optional protocol have allowed individuals to take a complaint before the CRPD committee where the applicant and the respondent state are parties, and the committee acts like a court, an international tribunal, and it decides that dispute. So it delivers some kind of a decision, which are called views. So this optional protocol is ratified by much fewer states than the CRPD itself. I checked the DARE countries. So from the countries where the DARE project is active, the UK, Belgium, and Portugal have ratified the optional protocol. Iceland has signed but not ratified, and Ireland and Switzerland have not signed or ratified the optional protocol. So only from countries which have ratified the optional protocol, you can take an individual complaint to the committee. But that should not stop you from being involved in a complaint from any country, or actually taking a complaint from any country, because it's not that difficult. So let me talk first a bit about the procedure, how it looks like, how you can be involved, and after that, why you should be involved, and what is even the purpose, how is it useful, and what is your added value as a researcher to this kind of process. So you might think that taking a case is something what only lawyers can do, but it's not so true before the CRPD committee. It's quite a simple procedure. So UN bodies, and especially the CRPD, are less formalistic than other international bodies, definitely less formalistic than domestic courts. So there is no obligation for clients to be represented by a practicing lawyer. It doesn't hurt, but it's not a necessity. So actually, there are clients who are represented by academics. They can be represented by anybody. Some are represented by NGOs, some by academics. Lawyers know about the procedure mostly. So practicing lawyers, I mean acting attorneys, they know about the procedure, and it's very rare for them to have specific knowledge on disability rights. It's very unusual to find lawyers like that. So there are many applicants out there who are looking for lawyers who would be able to help them with their case, and they cannot find help. That's where you come in. Having disability-specific expertise is often much more useful than having a lawyer who knows the procedure, especially here because the procedure is quite simple. So it's a very simple application. There is no form what you need to follow. You can draft it based on examples you can find online, or based on the optional protocol that gives you the basics. Of course, it is good if you can cooperate with somebody who already has experience with drafting the application itself, but that's not the most difficult part. So let's see how specifically, as a researcher, you can be involved. I already mentioned that you can actually represent persons who want to go before the CRPD with their complaints. And in a second, we will talk about how you can actually help find such persons. But also you can appear during the proceeding as an expert. So if you have contacts to the applicants, you can ask them to be invited to the case as an expert, or you can prepare a written submission and they can submit it to the court. And also, there is another way of being involved in individual cases, and that is called a third-party intervention, or an amicus brief. An amicus brief or a third-party intervention is submitted by somebody who is not a party to the proceeding, but has some relevant expertise or interest in the outcome of the case, and is advising the tribunal, in this case the CRPD committee, on how to decide the case. And that's something which can be done very easily. I have actually been involved in both as a representative of clients before the CRPD committee, and also as an academic drafting an amicus brief to the CRPD committee. So why would you even consider participating in such a procedure in any of these ways? Individual cases like this, individual complaints, which are decided by the CRPD, have tremendous impact on how international human rights law is developed. In our case specifically, they set very important human rights standards. They provide an interpretation of the CRPD, which applies not only to the specific facts of the case, but have a much more wider effect. They create a universal standard. Let's take a simple example. In the case of Fianna Given against Australia, the person could not access the polling station. The question was accessibility. So the committee decided her case, but in that decision, they made some general comments, and everything they say can be generalized to other situations. So now we have a more detailed standards on what states have to do to make their polling stations accessible. I mean, you can immediately see this affects not only Fianna Given, the applicant in that case, but any other person who is in the situation that they would like to vote and they cannot. And this is where your expertise becomes very important, because lawyers taking the cases are very much focusing on their clients' needs, and that is their goal. They have an ethical obligation towards their clients. When the decision is discussed in academia, we usually focus on the general standard And that's the important for us. It's not the fate of the specific client. Sometimes that can be interesting, but how it affects the standards. And there is a third element, which is, I think, very much missing from these deliberations, how the standard affects many other persons who are not appearing before the court. And that is what often only you know as a researcher. As a researcher, you know about some areas of disability rights better than anybody else. You know some things only you know, not even the CRPD committee members. They are often looking for information about how a certain decision might impact on other people, and they don't have that information, and you can bring that information to the case. Let's look at a specific example. There was a pair of cases, HM against Sweden and F against Austria, and both had quite complicated fact situations. So in HM, the person wished to live at home, but they needed a pool for that, for their hydrotherapy. So that was their way of being able to stay at home. So they were complaining that the state refusing them to build a pool next to their house was violating their right to independent living. And the committee accepted that complaint and decided that yes, Sweden should allow that person to build a pool next to their house. In a quite similar in the sense that it also concerned independent living, F against Austria, the person was complaining that because public transportation is not accessible for him because of his visual impairment, they are not able to live alone, live independently, and as a result, they will need to be institutionalized. And the committee in that case decided that the right to independent living was not violated by Austria. I mean, just describing these cases should immediately alert us to the fact that if the committee takes such a general decision, it affects so many other people in very different circumstances. So it's building permits in Sweden. How can they take disability into account? I mean, there was a reason why they didn't allow pools to be next to houses, which we actually don't really know. It came up in the decision, but it's not discussed in detail. The committee itself didn't really know. The government provided some justification, but there are many other persons with disabilities with different needs, and many other persons without disabilities with interests and concerns. And we don't know how the decision affects them. How, for example, funding implications of those rules were not present in the decision, and would be very important and interesting if the committee could take those into account. They didn't. Similarly, in F against Austria, how public transportation contributes to independent living, and what are the transportation needs of persons with disabilities which are essential for independent living, is something which is little talked about and was not really a central part of the court's analysis. The CRPD committee's analysis. The committee, of course, tried to elaborate on that question, but they didn't have enough information. So somebody who was doing research on independent living and public transportation's effect on independent living would be a very valuable source for the CRPD committee in that specific case, and they could make a decision which would be probably more authoritative, more persuasive for anybody involved and for any state which has to implement the judgment or comply with that decision. So these are just few examples. You as a researcher researching a specific area of disability rights already have knowledge which could be relevant for the CRPD committee deciding an individual case. of course, not any individual case. For a specific case, your knowledge can be important. So how could you use that knowledge? Sometimes you can be involved, or it's very effective to be involved already from the time of selecting a specific case. If you're aware of a certain gap in the CRPD committee's interpretation or state's implementation of the CRPD, you can highlight where is a need which is uncovered. Often persons with disability themselves, they have complaints, but they don't realize that perhaps an individual communication can be a solution for that. So they will not look for lawyers. You can be the one who finds the gap and offers a solution for that. So you can be involved. You can be involved through organizations or helping lawyers or helping individual victims or even drafting a complaint on their behalf. Usually how it happens is that researchers became aware of complaints on the domestic level, and they get in touch with the organization or the victims or their lawyers and offer help with advancing to the CRPD. You can easily do that. And you can support their lawyers if they're willing to help, or you can support the applicants themselves to draft a specific complaint. In the communication itself, in the procedure itself, I mean, you can yourself represent the client, or you can help the client either informally with arguments or submissions on specific questions which you research and where you have expert information on how certain interpretation will affect certain persons, and so on. What is the general policy situation in the country? How it falls below the CRPD requirements, and so on. And the most valuable contribution you can have here is to help the CRPD committee to achieve more persuasive opinions. You can be the one who helps the CRPD committee not simply to deliver a good decision, but to deliver a decision which responds to the concerns and the counter-arguments which states implementing the CRPD committee on the ground can have. So let me conclude by providing a specific example on that. An example from my practice, which I very much like. The right to vote of persons with disabilities was first litigated before the European Court of Human Rights. And the European Court decided that it's not possible to disenfranchise persons under guardianship without an individual assessment. And it's a progressive outcome, Alajos Kis against Hungary, but not great. So after that, we took a case to the CRPD committee, and the case wanted to achieve not simply a recognition that disenfranchising somebody after an individual assessment is a violation of the CRPD committee, but specifically for the CRPD committee to say that individual assessments themselves are clearly violating the CRPD committee, regardless of their outcomes. So that would be a very clear standard, and to explain why that is the case. So a third-party intervention from academics working on the CRPD very much helped in that regard. So their intervention was cited by the CRPD committee, and at the end we had a very persuasive decision, which not simply says right to vote for everybody. That we kind of knew based from the CRPD, but very powerfully explains why even individual assessments are not permissible under the CRPD, why they are hurting persons with disabilities. So this decision was so powerful that it was better accepted by European states than the European Court's decision, which is rare. The European Court is a very authoritative body. Nowadays, already, I think 14 countries have implemented the CRPD committee's decision, which is a great success. And it's an example how researchers with their specific expertise, based on their specific research, help the CRPD committee. Well, I was involved as a representative, so that was one side as a representative, but also with their intervention to influence the CRPD committee's decision. Thank you very much. I'm looking forward to any questions you might have.
Thank you very much, Janos, for explaining how the individual complaint procedure works and its impact. So thanks very much again to all our 4 panelists for sharing your knowledge and insights. And I think now we'll move to the Q&A session. And as I mentioned before, please feel free to make a comment or raise a question in the Q&A box. And if it's not accessible for you, please raise your virtual hand and we ask you to raise the question. So I can see that some questions have been answered in the box. But I do notice that I think in the answer to questions that, for example, I think Jonas mentioned provide a link, but it's not, I can't click on it. So maybe Jill or Mary, if you can copy that message and send in the chat box, probably is more accessible for everyone. So we have the first question here raised by Muhammad. He raised 2 questions. So the first is that, are there mechanisms in place and or efforts by the CRPD committee to promote and strengthen the engagement between disabled persons and DPOs in the Global South and the committee? And the second question is, would you care to share your observations or reflections, if any, about this particular aspect? Okay, I think this question has been answered, but I don't know if Teresa or Jonas, you have anything to add. You can speak now.
Yeah, thank you. I think it is very useful to go to the website of the CRPD committee, because I know that there are guidelines on how DPOs can interact with the CRPD, and especially if you look in the rules of procedures, there in the newer one from 2016 in the annexes, there are guidelines on ways of engaging with the committees. Then the other advice I want to give is that I think there's at least one organization which needs to be mentioned in this regard, and that's International Disability Alliance, which is kind of a liaison organization for the CRPD committee, and they do offer a lot of training and help for other NGOs, DPOs on how to engage with the CRPD. So International Disability Alliance is also a very good address. Thank you.
If I may add, yes, I concur with Teresa about International Disability Alliance. I'm sorry for missing about it in my presentation. That is true that International Disability Alliance work globally and works very much on let's say on all issues, and when it comes to persons with rights of persons with disabilities, and there is a very good platform to participate. It is the conference of the state parties hold usually in New York, and actually will be held online. So that is really important platform, because you may meet there all stakeholders, so representatives of the state parties, governmental representatives, also organizations of colleagues, organizations from other regions, organizations of persons with disabilities, also members of the committee always participate there. So one of the best platform is to connect to International Disability Alliance and to participate in this annual conference of the state parties. Also, another way is actually I mentioned to the ongoing regional consultations. That is, you may check online on the committee's webpage, and you may check the dates, and the dates, and it will still be in Africa, in South America, and other regions. The next week, in a few days, there will be Western Europe, but now Global South region will come very soon. So you may you have contacts there, and but it is with regard to deinstitutionalization, with regard to inclusion in the community, and especially in the context of pandemic context. So that is a very good opportunity to interact with the community, to express your concerns, to express if you have your recommendations on how to address these issues based on the human rights standards and standards that are provided within the convention. Okay.
Thank you. And we have the second question here. It raised by also their PhD researcher, Radosh. He directed this question to Janos. He asked, can you maybe reflect a bit on the conditions which need to be fulfilled or the individual complaint to be considered as admissible? Would a person, for example, need to exhaust domestic legal remedies first? Janos, can you answer this question?
Thank you, Han. Yes, I can. And if I can, I would also like to address one of Muhammad's questions, which was already answered, but I would add something to it. So concerning Radosh's question, yes, in order for somebody to get before this, to submit a complaint with the CRPD committee, they need to exhaust domestic remedies, which means they have to go through the domestic channels, usually a court proceeding. But the committee is not as strict about this as, for example, the European Court of Human Rights. So that is the most important criteria. In other international proceedings, there is another criteria often that there is a certain time limit to submit the complaint. There is no specific time limit before the CRPD committee. And also the committee can make exceptions from the exhaustion rule when the application of the remedies is unreasonably prolonged or unlikely to bring effective relief. And I think this applies to many situations persons with disabilities have to suffer. So there are many problems on the domestic level for which there is no effective complaint procedure, which makes it often very easy to turn to the CRPD committee. But yes, as a rule, you have to exhaust the domestic remedies first, even if just formally, even if you know that the court will not help you, you have to turn to a court, they reject the application, then appeal, and then you can go to the CRPD committee. So if that is the case, it's always good or sometimes necessary to cooperate with a local lawyer. Concerning Muhammad's question, this often comes up also in Europe. Can you use the individual communication procedure from a country which hasn't ratified the optional protocol? So Ireland, for example, hasn't ratified it. And you actually can, because there are other ways of being involved. What I mentioned about researcher also applies to DPOs. So DPOs can be interveners in other cases, in cases taken from other countries. And international bodies do take interveners seriously into account if they have relevant information. So if you have a problem in your country which you would like to take a case on to the CRPD committee, but you cannot because the country hasn't ratified the optional protocol, look for other cases which were taken from other countries, and maybe you will find something which is relevant for your situation and intervene in that case. That can be a very effective strategy. Or even going forward, DPOs have good ways of cooperating with other DPOs from other countries. I'm seeing this more in Europe, but I'm sure it's happening also in other countries where somebody has a problem they want to raise before the CRPD committee, and maybe their country is not the best place to raise it from. Maybe it hasn't ratified the optional protocol, maybe it did, but maybe there is another country from which a case can be taken more effectively, and that DPO can help the DPO in the other country to take a case, and the result will benefit everybody. It's not just those from that country which can benefit from a good decision. Everybody in the world benefits. Even countries which haven't ratified the CRPD benefit. Thank you.
Thank you. Do other panelists have anything to add? Okay. Thank you, Radosh. And then we'll move to the next question raised by Edmore. And he's also a PhD researcher from that network. And he asks, how does the CRPD committee reconcile differences in viewpoints about the interpretations of the CRPD provisions when preparing a general committee, but I think you mean general comment here? For example, liberal and conservative interpretations of Article 12, Article 19, etc., and their relevance to certain regions or countries or cultures. I think this question may be more appropriate for Teresa or Janos to answer.
Yeah, I'm happy to come in on that. That is a very interesting and difficult question, and in most cases, as long as I was a committee member, we tried to reach consensus within the committee. And so we discussed as long as possible in order to reach consensus. If we could not reach consensus, we went by voting. Actually, this was at least in two committees, in two general comments, I remember the case. And it wasn't sometimes not very easy, and that is often a case. But in order to make you maybe what helps in order to understand the framework of the committee is bound by its own jurisprudence, and the committee is also not bound but asked to recognize the jurisprudence of other treaty bodies, because the Office of High Commissioner asked us to harmonize, or asked the committees to harmonize their jurisprudence, which is of course not the case. If you research on some of the issues, there is a much variety in lots of differences between the jurisprudence on some topics between the treaty bodies. But in order to reach consensus, then it always helps to provide the committee with its own jurisprudence. And as soon as you can say, hey, this is what the CRPD committee has said before, stick to your own jurisprudence. That helps. In my memory, it has helped a lot to reach consensus in the committee. Otherwise, you have to go by majority vote.
Yeah, if I may add also, I was not the part of the committee when the general comment on Article 12 was developed and was adopted. And but I think that this article, both article, there is no confrontations, I would say, or very different interpretations of this article. So I think that the provisions of the convention are very, very clear. So there is no, very clear when Article 12 focuses on the supported decision making instead of substitute decision making, and we very there is no question about abolishing or not abolishing substitute decision making. It is very clear that it is to abolish, and especially there are when we have consideration of the state parties report and I would say inquiries. I do remember the inquiry in Hungary. It was in relation to Article 12 and Article 19 that we've seen and we provided within our support how discriminatory might be substitute decision making when it is combined with the deinstitutionalization, and when the deinstitutionalization process, the so-called deinstitutionalization process, is going with hand in hand with the substitute decision making. So there is no different interpretations and conflicting interpretations. And when it comes to these articles, I mean Article 12, Article 19, and especially Article 19, the issue is that somehow stakeholders does not. There is a lack of awareness about these articles. For example, Article 19 usually is used the buzzword like community-based services, and that is. It is all three such provisions and about control of the life, about a personal assistant, about access for general for services for design for general population are missed. So just usually what we need to have a very clear awareness about the provisions. Yeah. Thank you.
I think Janos have something to add. I see you raise your hand.
Yes, just a very few short note. It's a very interesting question because there's a lot of debate about how a certain view prevails. But I just want to highlight that you can actually influence that. It's an important part of the individual communication, how you select a client. And you as a researcher can be aware of things which lawyers are often not. What are the conflicting views and possible interpretations? And you select a case to put that interpretation which you want to achieve in the best light. In other words, there are clients who can make a certain viewpoint look very sympathetic. Let me give you an example. If you want to argue that institutions should be abolished, if you take a case from of a person who is living in a great luxurious institution, you might not achieve the best outcome. It should not be relevant, but it is. If you take a case from a horrible institution, again, for the general principle, it should not be relevant, but it will be relevant in the mindset. So implicitly in the mind of those who will be deciding the case, that this person really was wronged. They are harmed, and we need to help them. And that will very much influence which interpretation of the general principle prevail. That's all I want to say. I have specific examples on this, but we don't have time for that. But these even come up in academic writing sometimes. So by that way, helping representatives to select good cases, good applicants, you can actually very much influence how certain viewpoints prevail in jurisprudence.
And Dragana, you have something to add?
Yes, thank you. Well, I can share my experience. This one was with the Committee Against Torture and on the issue of torture in social care homes in Serbia. And what I previously said, the importance of personal testimonies so that the committee members can actually, you need to describe the situation, and sometimes even visual is what's needed to convene a certain message. So in this particular case, Disability Rights International prepared a report on Serbia, and I went to Geneva to give a personal testimony about our report, but also I brought photos of children living in Serbian institutions and to show the treatments that they were exposed to. And it was then that the Committee Against Torture said, yes, this is torture based on the evidence provided. So you have to use definitely examples. You cannot base always your efforts on an analysis on, you have to show how a situation affects an individual person living in a particular circumstances. So definitely powerful stories, powerful testimonies are very important in addressing these issues and contributing to this process.
Thank you. Thank you very much to our panelists, and thank you, Edmo, for the question. And due to the time limits, I think we should move to the next question. It's from Martina. I hope I get your name right. From the European Union of the Deaf. And the question direct to the two committee members. It says, my question to the committee members will be how else the regional organizations such as European Union of the deaf could support the work of the committee. For example, would the committee find the comparative information useful to highlight that a country under review could do better in comparison to other countries in Europe? Thank you. So who want to take first?
Yeah, hello, Martina, my fellow from Lithuania. We get in touch several times before discussing about this issue. Sure that we need that regional consultation, including association of the deaf or the national associations of the deaf. We need information from you about the provisions and implementations of the convention in this regard in the country, in the state party. And we don't need necessarily comparative information. It is not, we don't make a comparison between the countries, but we need testimonies. We need information about legal and regulatory provisions with regard to the implementation of the convention, and also when it comes to association of the deaf, we would need also there were extensive discussion before with the association, the National Association of Deaf in regard to some provisions of the convention, especially and including on Article 24 on inclusive education. We would need also, the committee would need the recommendations, and then on how the committee, but also the state parties would need information on what are the best ways to implementing inclusive education, for example, inclusive education when it comes to deaf children. So I do remember for Estonia that we just had the constructive dialogue. So they provided very good information, the National Association of the Deaf Estonian. So very detailed and showing intersections with the different areas, and so that helped a lot. Me as country rapporteur, that helped a lot the members of the committee to draft the general concluding observations. Thank you.
Thank you, and Teresa.
Thank you. Yeah, I concur with what Jonas said, but I also want to say that I'm often asked to say which country is the best or which is the worst. I mean, you as a member of the committee should know, and it's true, but during my 8 years, I have reviewed 70 countries, but what the committee does not do is compare countries. And that has, I think, a very good reason. It is not the blaming and shaming, which is, of course, part of an important tool in human rights awareness, I would say, but it doesn't work with treaty bodies or from the side of treaty bodies. The treaty body has to show that it is not partisan, that it is objective. And so you do not find any document, I think, of the CRPD committee which says the country X is doing so much worse than country Y or Z, because you want to respect that each country has to find its own path in its own context, historic, economic, cultural, and to find a good way and to implement and monitor. So, but nevertheless, the information you offer would be important for the CRPD committee, because the CRPD committee uses a lot of confidential information. It can never make public. And that was also very important during my time as a country rapporteur, as well as a member of the General Common Working Group or Inquiry Working Group, because when you know that in that region, countries can do so much better, then you have much more courage or confidence as a committee member to go forward and say, and we do ask and recommend to this country that you do this and that. But we will not be able, or the committee will not be able to say, because country ABC is so much better as you, we ask you to do this or that. So that needs to be kept in mind. So if you want to make your organization also advertise your organization as doing good human rights awareness work, then you need to find a good way to present your, publish your findings, but do not expect the CRPD committee to cite your findings, because it cannot, it must be impartial. That's what I wanted to say. Thank you.
Thank you very much. I suggest we move to the next question, and if other panelists have anything to add, you can type the answer in the chat box, in the Q&A box. So next question is also from their researcher, George. His question is, how does the committee handle sensitive information? Sometimes groups are afraid of sharing certain info in public reports or meetings. What are the protocols on this? Maybe also Teresa and Jones, you answer the questions, I guess.
I would leave this question for the afternoon session. I think that is a very sensitive question.
Okay. Okay, so then let's move to the next question then. It's also from a fellow researcher, Marisa. Her question is, I would like to ask for some reflections on making yourself available as researcher with disability expertise. Aside from networking and working alongside with DPOs and NGOs, are there other ways of making your expertise known to individuals who may not even know there are researchers with your specific expertise? And Janos, can you answer this question, please?
Yes, thank you, Han. Yeah, that's a good one, because I have been in a situation many times where I wished I could be involved in something and I wasn't. So there is no good answer to this, but you can do your own research and know who is planning what kind of action. So if there is a court proceeding, especially organizations, they often advertise it. They have press releases and so on. So if you are aware of a certain issue happening in your area, definitely contact them. That works. So for example, if organizations or even victims are planning court cases, you can learn about it through the press and you can contact them directly. That actually happens quite often and it works. Other than that, networking in general is very useful here. And keep in mind that disability scholars are quite a small group. So across the world, there aren't that many people who are specializing on disability rights. And very often they have links with DPOs, if for nothing else than for research purposes. So if you're interested in a certain country, contacting scholars there who will know DPOs in that country is a very good way to start. And you can almost always easily locate the type of clients or the type of organizations with the specific problems you are interested in, and let them know about yourself and your willingness to help. It's a small world, basically. So specifically, recently, I wanted to get involved in a Danish and the Spanish case. The disability scholars in that country knew immediately who are the relevant organizations, and contacting them immediately gave me contacts to that group and to their lawyers who were involved in those cases. So it's not unrealistic. Thank you.
Thank you. And there's no further comments. Let's move to the next question. Okay, so we have the next question from Adnan, and the question is, how is psychosocial distress linked to physical disabilities? If Adnan is there, can you explain more? Maybe you can turn on your mic and explain more on the question. What do you mean? Because this is not a very clear question. Okay, maybe you can type answer in the Q&A box.
Sorry, Hans, Cormac here. But who are you looking to speak? Sorry, I didn't catch that.
I think name is Intel MC20.
Okay, they're allowed to talk now.
Okay. Hello?
Hello.
Hello, can you explain more on your questions,
Hello.
please? Thanks. Hello?
Hello.
Hello? Can you hear me?
Yes, I can. Hello.
Yes, we
Hello.
just read your question.
We are persons, yes. She's saying we are persons with
we are persons with severe psychosocial problems, psychosocial health conditions. Yeah.
we are encouraged
by various partners in the National Mental Health Steering Committee
to regard persons with disabilities to act as one. Our membership.
Hello.
Yes, we can hear you.
Yes. So our membership
in the National Commission for Disabilities is a case now. Then how can something continue? Are you the right thing?
Sorry, do you have a question for the panelists?
Well, the question to this one now is, how can SOFNA be of support to the CRPD in Sierra Leone on this research that is being discussed?
I assume that, just to clarify, I assume your question is how your organization can support the implementation of CRPD?
People that are physically challenged.
This is my second question, actually. I'm here with Paul. We're sorry we are late, but yeah, we've been following actually. Yeah, so we want to know how our organization can support in this research.
Thank you.
We are not physically challenged as such. We have psychosocial problems, psychosocial disabilities, and which is not easily seen. So that is why we are asking, how can you link us to the physically challenged, the blind, for example, because the psychosocial, the deaf, for example, but for us, people don't consider us most of the time because they don't see our disability physically.
Thank you. Okay, so I think the question for our panelists first is that the maybe more like discrimination and challenges faced by people with psychosocial disabilities and how to address the issue. And second is how they can support the CRPD implementation in Sierra Leone.
Yes.
So thank you. So maybe if we can have Teresa and Janos, do you want to address these questions? Thank you.
Thank you very much for this question. It is a frequent problem we see in some countries that people with psychosocial disabilities are not recognized as part of the disability movement. And I would recommend you to go to umbrella organizations, just which are not linked to an impairment, but umbrella organizations like Disabled People International, or Inclusion in International Disability Alliance, who might help you to find a liaison in your country or in your region, because that is really important that all people with disabilities are taken on board and all voices are heard. And we hear that very often, that persons with psychosocial disabilities are left behind. So I would recommend you to find an umbrella organization either in your country or in your region, or if not, the two organizations I mentioned are umbrella organizations, and maybe they can link you up.
Thank you. Janos?
I would just add one thing, that it is a general problem in many countries that persons with psychosocial disabilities are not considered by part of the disability movement by the state for various reasons. But luckily, the CRPD committee has its own standards, so you can always have direct access to the CRPD committee. So you can actually use that to put pressure on your own government to get you recognized. So for example, nothing stops you from writing a shadow report and highlighting this exact problem, that you cannot be involved on the national level. That would be one way of achieving proper standing also before the national authorities. Thank you.
Yes, if I may add, that's true. You may send your report of your organization to the committee, directly to the committee when your country is, when your report of your country is considered in the committee. Of course, that is true that it will be accepted and will be included in the consideration. Thank you.
Thank you. I think we have 4 questions left, and we have like 10 minutes for the event. So maybe we just give really brief answers to these remaining questions. The next question comes from Masayuki, and it says, now, if the DPLs want to communicate directly with the CRPD committee, you will have to go to Geneva. My question is, in the near future, is there any chance that the CRPD committee itself will go to the country being reviewed? In this way, there will be more chance for more DPLs and the person with disabilities to communicate directly with the committee. Is there any discussion regarding this kind of idea? And Dragana, do you want to address this question? Thanks.
Yes, thank you. I guess that Jonas and Theresia will probably address the logistic issue, but I wanted to say that, yes, you can travel to Geneva. If you need to travel to Geneva, you can always ask support from International Disability Alliance. I know that they have supported many disability right organizations to take part in their country when the report of their country was being considered, but also you can take place in consultations virtually, especially now during this time. Original consultations that are taking place online, so it's a chance to take part in these sessions virtually. But always, so personal contact is important, but it can be achieved also through, you know, written submission and or virtual or video testimony as well, which is a very important and very useful tool that we used a couple of times. So your testimony can be taped and showed during the, for example, consultations. But I guess that the committee considers many countries during one session, and it would be impossible for committee members to travel to these countries. But I mean, Theresia and Jonas will be maybe better suited to address that particular point.
Yeah, thank you. I fully concur with Dragana. That is true that that in-person sessions, in-person meetings are much better. Or it is always good. It is always good to meet, to interact in person. But actually, we hold already 3 online sessions, and only 1 interactive dialogue with the state party. But you actually virtually we can meet, and we can organize all meetings and not necessarily to go. Even we don't go now to Geneva, the members of the committee. So just you can go through secretariat and to ask meetings with the country rapporteur or members of the committee. Also, you can go through the International Disability Alliance, the organization which is the stakeholder of the committee. So you go through them, and virtual meetings will be organized. It might be individual, or it might be with the representatives of organizations. So that is not the issue, I think, today.
Thank you. Are there any short comments? Okay, so let's move to the next question. I think it's from Lucas. Asked, is there any way that the committee can intervene against the misinterpretation of the CRPD that are proclaimed in public by state parties? And Janos, you want to ask this question?
Yes, I don't think officially we will make such a explanation, let's say, or something, you know, interventions when there are some misinterpretations in the state party. But however, there might be some, for example, we have an example, a recent example in Spain, and there were some misinterpretations by governments, and the CERMI, the organization I mentioned you before, they addressed to the committee and they ask us our opinion, and one of our members, Spanish-speaking member, has participated in the debate with the government and in debates organized by CERMI and the government. So it is through interactive way, not an official position, because it is not the way we in fact proceeding.
Thank you. Janos, do you have something to add?
Basically, Janos covered it. I just wanted to say that the committee basically communicates through concluding observations, general comments, and individual decisions. So to put the government right is often the domestic civil society's responsibility. Using the CRPD committee's work and making use of these opportunities is a good way to do it.
Thank you both. Regina, do you want to add anything? I see you open your mic, turn on your mic. Okay.
Yeah, Janos really covered, I think. I wanted to comment on I think there was a question about whether the alternative report needs to cover all articles of the convention.
Yes, that's the next question by John, yeah.
I mean, no. It's good if you can answer all the questions, and usually comprehensive alternative reports, which are usually prepared by the umbrella organizations, do address all of the articles, but also that doesn't stop individual organizations to submit separate reports addressing one or several articles, which are especially important for the mission of that organization. For example, if you are an organization of persons with psychosocial disabilities, like we heard before, you have issues of particular concerns, such as participation of persons with psychosocial disabilities in the processes in your country. So you can address a particular article and make your submission. So that when I spoke about the ways that you can contribute, it's exactly about that. Do you want to participate and to submit a comprehensive, and do you have capacity to prepare such a comprehensive report? Or your capacity as a local grassroots organization is actually to address one particular issue. So if you have limited capacities, and if you can address only one particular issue, that shouldn't stop you, and you should go ahead and do get in touch with the committee and submit your contribution, because it's important that committee hears what might be missing from some other reports made by other organizations from that particular country.
Thank you, Dragan. I was just to add, probably I misled it a little bit when I said that the alternative reports must cover all articles. It is not, but it is usually about umbrella organizations. So usually umbrella organizations they try to cover all articles, but what we need, that is true that there is a word limit within the documents, so you can expand very much on specific issues. And what the committee also expects, the reports by more specific on one article or on several articles, and that goes deep inside with the testimonies. So that is true that it's not necessary to cover all articles. That's true. Thank you.
Yes, I can give an example. When the alternative report on Serbia was being prepared, MDRI Serbia participated in preparation of the alternative report by contributing with our experience to the comprehensive alternative report, which was submitted by the National Umbrella Organization. But we also made a separate submission where we focused on few articles that are of particular concern for our organization, such as deinstitutionalization, inhuman and degrading treatment, also a position of women with disabilities in institutions and gender-based violence. So you can basically contribute to the comprehensive report, but also file your individual submission where you can go in depth, as Jana said, in the issues that you couldn't cover in such a large document, which is still limited by the number of words you can submit.
Thank you. And I think let's move to the last question raised by Fiona, and it also connect to the what we just discussed about shadow reports. The question is, can individuals submit their own shadow report if the issues are not being fully represented by either a regional group or a national DPL? Is it the best option for people in the absence of ratification of optional protocol? Who want to address this question first? Maybe, I don't know, Dragana and Janos, do you want to take this question?
Hands raised.
Theresia has her hand up.
Oh, sorry. Yeah.
Well, I was saying that I haven't seen a shadow report yet by an individual person, but it's of course possible, but it will have less strength and less emphasis within the committee. What is really appreciated by the committee, which is really, I mean, what you need to know during my time, at the end of my mandate, I had to read for each session 1,500 pages minimum. That was just the state party reports, just the shadow reports, just the main individual communication. That was it. Not talking about all the other information you have to read along. So if you want to reach the committee, if you want to provide useful submissions, then keep that in mind. Keep your submission short and try to give joint statements. As Dragana and Janos have mentioned earlier, it is giving so much weight to your voice, to your intervention. If you find a coalition of people, of organizations who work with you. Also, what is very helpful, especially in inquiry procedures, to have a coalition of universities, researchers from universities, DPOs, and maybe most importantly, in independent monitoring mechanisms from that country involved. And that makes a huge impact in the committee. And then have the submission short, precise, have links where people can go in, but just in order to enable the committee members, to the individual committee members, that is the best thing to do, I think.
Are there any comments from other panelists? Okay, well then if there's no other urgent comments, I think I'm closing the event today. So thank you very much for all the panelists today. And thanks to Joe and Mary for organizing the event. And also thanks to our sign language interpreters. And thank you very much all again for coming and participating in the webinar today. And thank you, bye.